I'm Katie, and I'm currently taking the Real Estate Pre-License course through Metro Brokers Academy School for Real Estate. I want to invite you to study with me on my channel. We will review all the chapters individually, as well as the vocabulary you need to know within each chapter. So don't forget to like and subscribe at the end. Without further ado, let's move on to today's topic. Real Estate Exam Prep, Contracts Review with Katie Landers Does Real Estate. Before we get started, let's take a look at today's outline regarding contracts and all the things we will be covering. You can find this outline in the description below this video. After we review this chapter, you can also look forward to a chapter quiz and vocabulary, so don't forget to subscribe. Let's get started. Creating contracts. When creating contracts, it is important to note that contracts can be oral, but with the statute of frauds states that most real estate contracts, with very few exceptions, at least for 1 year or less, for example, must be in writing to be enforceable. Now, enforceable means that it can be enforced in a court of law. The law allows for enforcement of contracts, but an enforceable contract must always be valid. A valid contract may, however, be unenforceable. There are lots of things to remember when creating contracts. Contracts can either be expressed or implied. An express contract is clearly communicated orally in writing, while an implied contract is created by actions. The promises are not expressed but manifested by the conduct of the parties. Contracts can also either be valid or void. A valid contract contains all essential legal elements, which includes consideration, assent, legal capacity, and legal purpose. Now, we will review these in a few more slides more in depth. A contract is void if any of these essential elements previously mentioned are missing. A void contract is not a contract at all and never was. Contracts can also be voidable. A voidable contract remains valid until it is rescinded. A contract is said to be voidable when all essential elements are present, but one or more may be removed, option of the party who has acted under a disability. We will go over some examples of this shortly. Contracts can also be unenforceable or enforceable. When a contract is enforceable, all parties may be forced to perform per the contract in a court of law. When a contract is unenforceable, it means it cannot be enforced by either party in a court of law. Contracts can also be executory or executed. When you have an executory contract, it means that the contract has not yet fully performed. Something remains to be done by one or both of the parties. I like to remember executory contracts as unfinished business. There's something remaining that hasn't been done yet, so it's unfinished business. When you have an executed contract, it means that all parties have fully performed their obligations. I like to remember this executed contracts as finished business. It's done. There's nothing else that needs to be done. Lastly, a contract can either be bilateral or unilateral. When you have a bilateral contract, it means both parties promise and therefore incur obligations. I think of bicycle because it has two wheels, bi meaning two, bilateral contract, both parties. When you have a unilateral contract, it means only one party is making a promise for the action of another. When I think of unilateral, I think of a unicycle because it has one wheel. Uni means one. Unilateral contract, one party. Ooh. All right, now essential elements of a contract. There are 4 essential elements of a contract, and you can think of call: consideration, assent, legal capacity, and legal purpose. For consideration, this is anything of monetary value to induce another to enter a contract. Good consideration is something without monetary value, love, and affection. For example, good consideration in real estate is when a buyer and seller agree to the terms and conditions for the purchase of a home. This is good consideration as it is something legally permissible and is good between the parties. Assent. You have mutual assent and genuine assent, but first let's discuss mutual assent. Must be a meeting of the minds or mutual agreement on every detail of the contract. Mutual agreement is reached through the process of offer and acceptance. A person making an offer may withdraw the offer at any time prior to being notified that their offer has been accepted. Actual communication is either oral or written communication to the offer or that the offerer has accepted the offer. Constructive communication is when the contract is created when the message is sent, not when it is received. So if you send it out in the mail, it starts that day and not when it actually gets to them in the mail a couple days later. For genuine assent, this is an essential element of a contract which requires that all parties enter the contract under their own free will, absent of fraud, misrepresentation, duress, menace, or undue influence. Innocent misrepresentation is a misstatement of a fact made without any intention to deceive another person. They didn't mean to do it. If the matter is of material value and the other party relied on it, the contract is voidable. Fraud is a deliberate and malicious misrepresentation of a material fact in a transaction on which one or more of the parties to the transaction relies and thereby suffers damages. It creates a voidable contract, so one of the elements can be taken away, so it then becomes voidable. Possible court damages and possible sanctions for a licensee will occur. Let's talk a little bit more about fraud for a minute. There are 4 types of fraud we need to remember: actual fraud, negative fraud, constructive fraud, and negligent misrepresentation. Actual fraud is deliberate and malicious misrepresentation of a material fact. It means they did this deliberately. Negative fraud is concealment of important information, voidable by the injured party. Constructive fraud is the misrepresentation of material facts without intending to deceive or mislead, but involving a breach of duty, such as negligence or carelessness. Negligent misrepresentation is a false statement believed to be true, but is made without sufficient grounds for such belief due to carelessness or negligence. When relied upon by another party, it has the same effect as willful misrepresentation and results in constructive fraud. Then you also have mutual mistake. Mutual mistake occurs if both parties to a contract are mistaken about certain facts vital to a contract. Negligence is breach of duty resulting from failure to exercise reasonable care required by the circumstances involved in each individual case. Then we have duress or menace. Duress is the use of force to compel a person to enter into a contract. Menace is the treating of force to compel someone to enter a contract against his or her will. Lastly, under genuine assent, let's discuss undue influence. Undue influence is using a position of trust and confidence to take unfair advantage of another person to obtain a contract. For legal capacity, the legal capacity is the legal ability to enter into a contract. You must have competent parties. Minors. A contract signed by a minor is voidable at the minor's option. The contract can be voided any time up to the age of majority, which is 18, and a reasonable length of time thereafter. For the mentally incompetent, if a contract is signed by a party who has been declared legally incompetent, it is void. Now, if a person later claims they misunderstood after the fact, the court might consider the contract to be voidable. If someone is intoxicated, A contract signed by a person under influence of drugs is voidable. If there is a power of attorney, who is a person who authorizes another person to act on their behalf, or attorney in fact, then the contract is valid. If the contract is signed by a corporation, which is a legal entity which can enter a contract, the contract is valid. If there are court appointees, who are administrators, trustees, or guardians who receive authority from the court, the contract is valid. Moving on to legal purpose. Lawful purpose means that whatever a contract requires of the parties, it must be lawful. If the purpose of the contract is illegal, in whole or in part, the contract is void. In writing, as required by law, the statute of frauds requires certain contracts to be in writing and signed in order to be enforceable. It includes all contracts for the sale of an interest in real property, all contracts that cannot be performed in 1 year, all contracts that cannot be performed in 1 year and for personal property valued over $500. The use of forms in real estate contracting. Parole evidence rule relates to the fact that written agreements always take precedence over oral agreements. Let's repeat that. Parole evidence rule relates to the fact that written agreements always take precedence over oral agreements. You have an addendum, which is a page added to a form contract for the purpose of including essential terms or to provide supporting documentation such as plats or a power of attorney. The addendum should be incorporated into the contract by reference, then initialed and dated by the parties, and it can also be called an exhibit. The discharge of contractual obligations. We're going to go over performance, supervening illegality, mutual agreement, novation, destruction of property, operation of law, and assignment of contract. Starting with performance, the performance executory contract is a contract in which all terms have not yet been performed. Again, unfinished business. Time is of the essence means that all time limits in the contract must be strictly observed. Think about the due diligence period. They only have a certain period of time to do that inspection or really decide if they want to move forward, because if they put some earnest money down for that property, they only have that time within the due diligence to say, hey, I don't want to do this anymore, and get that earnest money back, or continue on, and they won't be able to get their earnest money back after the due diligence period expires. So time is of the essence means that all time limits in the contract must be strictly observed. Supervening illegality is when a change in the law makes the obligations under the contract legally impossible to perform. Mutual agreement or mutual rescission is when all parties to the contract mutually agree to cancel the contract. Novation is the substitution of a new obligation for an old one or a new party to the transaction. If destruction of the property occurs, a contract may give either party the option to cancel the contract if the property is destroyed or damaged before the transaction is completed. Operation of law, which is voidable contracts, applies to voidable contracts. A party may unilaterally, so one party, may rescind a contract if the contract is considered voidable for any reason. Assignment of contract is the transfer of one's right and obligations under a contract. The assigning party retains ultimate liability. Remedies for breach of contract. Contractual remedies, often parties to a contract will agree to certain non-judicial remedies in case of default. Mediation is an independent third party who works with the disputing parties to help them resolve their differences. Arbitration is a disinterested party who will hear both sides and make a decision as to how it will be resolved. Liquidated damages is where a contract might specify in advance how much an injured party is entitled to receive if the other party defaults. The sum agreed upon must have a reasonable relationship to actual damages that might be suffered. Remedies provided by the law. Damages. If the loss suffered can be expressed in terms of money, the innocent party may sue the defaulting party for monetary damages caused by the default. Specific performance. In a default, the innocent party may seek a court order requiring the defaulting party to carry out the precise terms and conditions of the contract. When a buyer is suing a seller for specific performance, they must first file a tender with the seller, which is a formal offer to perform under the terms of the contract. Rescission is canceling of a contract that and the return of the parties to their original positions. So you have unilateral rescission. If the injured party decides to rescind, the other party is notified and any payments that have been received must be returned. And then you have mutual rescission. And this is when an innocent party agrees with defaulting party to cancel the contract. Both parties must sign a written notice of cancellation. Then we have the Statute of Limitations. This is the time an injured party has the right to seek legal remedy. Unless the legal steps are taken within the legal time, the injured is stopped from taking action at a later time. Now let's move over to real estate contracts. We have listing contracts, sales contracts, option contracts, leases, property management, affiliation agreement, land contract, and other. Listing contracts are when a listing agreement serves as the broker's contract of employment. It is an agency agreement wherein the principal, the seller, authorizes the agent, who's the broker, to market the property. Sales contracts are the purchase and sale agreement is extremely important. Once signed, the seller is committed to sell and the purchaser is committed to buy. Option contracts is a unilateral contract in which a property owner, the optioner, agrees to give a prospective buyer or lessee, the optionee, the right to buy or lease the property for a certain price and within a certain time limit. Leases. In a lease contract, the lessor conveys to the lessee an exclusive right of possession and control for a specified period of time and for consideration called rent. Property management is the agreement in an agency contract in which the principal, the owner, authorizes the agent, the broker, to carry out some or all of the responsibilities contingent upon managing the property. Affiliation agreement or employment contract is signed when the salesperson or associate broker joins a brokerage firm. Land contract, also called installment sale contract or a contract for deed, is an alternative method of financing a home purchase. The buyer does not have legal title but is said to have equitable title, which is the buyer's interest in a property upon entering into a sales contract until the legal title is passed. The buyer makes regular payments to the seller towards the purchase price of the property. The seller will convey the title when the full price is paid. And finally, other. Other contracts are not typically executed by a licensee, but they should get more familiar with deeds and various contracts used in mortgages, mortgage lending, security deeds, and trust deeds. Now, closing the transaction. Finally, the closing of a real estate transaction is the procedure of finalizing the contract. The deed is delivered to the buyer in exchange for the agreed upon purchase price. In some states, closing is handled in escrow by a disinterested party who performs the necessary duties according to an escrow agreement that is prepared and signed by parties to the contract after their agreement has been finalized.
And that's all I have for today's topic, folks. Thank you for studying with me, and don't forget to like and subscribe for more content.